We're often asked to review severance packages that have been provided to our clients. If you've been provided with a severance agreement, it is very important that you understand what you're signing. Severance is generally a voluntary process. Typically, companies don't have to offer a laid-off employee anything as they're leaving the organization. Sometimes companies do want to provide a little bit of additional compensation to a laid-off employee to help that employee transition to a new employer. Also, the company gets a promise usually in a severance agreement that the departing employee will not sue the company. It is always important that you understand what you're signing because in addition to the release of claims, there are frequently other obligations that the employee is taking on in these severance agreements. These additional obligations include non-compete, non-solicit, and non-disparagement clauses. These can impact where an employee can work after they leave a company, what an employee can say about the former employer, and other activities that are impacted as an employee exits an organization. Severance negotiations are a great time for employees and employers to resolve their issues. If you have a claim that you would like to pursue against your employer, you need to make sure that your severance package accommodates for release of that claim and that it is acceptable to both parties, that the amounts offered and the obligations undertaken are sufficient to bring the matter to a resolution. If you are looking at a severance agreement, just make sure that you understand what you're signing before you sign it. If you need to have an attorney look at it, it makes a lot of sense to do that.